Welcome to The Ethical Advocate for Accidents.
Hello and welcome back to The Ethical Advocate for Accidents with James K. Sadigh. With more than 35 years of experience handling personal injury and insurance claim cases across California, James has seen how recovery can take unexpected turns, especially when medical treatment causes new harm. My name is Kevin Rosenquist, and today we're talking about what happens when the care meant to help actually makes things worse, and how injured patients can protect their rights while focusing on healing. James, welcome back.
Good to be here.
You know, we usually think of an accident as the main injury event, but sometimes the real damage happens afterwards. How common is it for clients to come to you because their medical care went wrong?
Not very common, but it has happened at least a couple of dozen times in the past 35 years.
Yeah, I was going to ask if you could share a story.
Well, yeah, a few years ago, a lady was referred to me who was walking into a restaurant and because of the negligence of the restaurant, tripped over, hit the wall with her shoulder, and apparently had a dislocated shoulder. So we got into a case, and later on we found out that, as a matter of fact, the emergency room doctor had made a mistake that aggravated her injury and treatment. What it was is that she had a dislocated shoulder, goes to the hospital, and the doctor, orthopedist in the hospital, wanted to go or already had tickets to go to a vacation. So basically tells the hospital people, stabilize her for a couple of days until I come back after the week. But what happened is the doctor could have easily just jam the shoulder back in the place, which is a painful thing, but it's only for a while, and she would be fine. And medical bills probably would not have been more than $10,000 altogether to do that. But because of the entire weekend, she was stuck in the emergency room and nobody had done anything for it. Now, the shoulder could not be pushed back into a position, and now she needed an open surgery.
Holy cow.
So the value of the case from, I don't remember what to say, but let's say from $30,000 or $50,000 value, all of a sudden went to high six figures. And of course, the restaurant and the defense attorney were talking about, it's not our fault if the doctor made a mistake. And we had to deal with that situation.
What does happen in that situation? You have to get involved with the hospital, right?
Well, it's very interesting. I remember when that case came, I actually remember the very old case in law school that stands for proposition that the medical malpractice or mistakes is the foreseeable damage from any injury, which is very unlikely. It's amazing that we have that rule in the United States. And based on that, the person who caused the original injury ends up being responsible for it. So I went back and found that case, and I presented it to the defense attorney for the restaurant. And we ended up making a deal. We settled the case for the full value of my client's injury, with the surgery and everything that she went. But we signed and assigned our right of medical malpractice to the restaurant so they could go and try to recover whatever from that doctor.
What that's happened, how it works. Okay.
Yeah. But normally, a medical malpractice or mistake is part of the injury that the original person who caused the accident will be responsible.
Okay. Interesting. So if someone suspects their treatment might have caused harm, should they confront the hospital, the doctor? Should they file a claim right away? What is the process that they should follow?
Well, that's a totally different set of laws when it comes to injuries from the accident or injuries because of the medical negligence. In California, we have a certain set of laws we call MICRA that deals with medical malpractice and professional malpractice on part of the physicians and hospitals and healthcare professionals. In that situation, the statute of limitations are different. And usually we have to give a 90-day written notice to the healthcare professional that we are planning to bring a claim against you, and we're giving you 90 days to evaluate your own position, not only to provide the copy of your entire file regarding this patient, but also see if you want to engage into resolving the case. And then after 90 days, we can file a lawsuit against them. It is not a very good idea for the patient himself or herself to approach the doctor with that manner, because then you have no idea what things you're saying that may actually go against you later on, or that what the doctor is going to do. It is always better to get the complete copy of the doctor's files and notes before approaching the doctor and letting them know that there may be a negligence case coming against them, because what if they change the record?
How do you tell the difference between something that might be a true malpractice case and maybe just an unavoidable complication?
Well, as an attorney, I cannot do that. A lot of people, say that these are all expert opinions. That's why medical malpractice cases are extremely expensive to go. First, we have to get all the records, and then we have to approach an expert in the area. If, let's say, if it's a chiropractor, it has to be another chiropractor. If it's a neurologist, it has to be another neurologist. Take the records and the whole story to these experts and say, please review this. Here's your fee, and let me know that if there is a malpractice here, or is it just an unavoidable consequence? By way of example, years ago, a case was referred to me that the patient had gone through just getting the blood out of the vein for with a phlebotomist for a checkup. After that, he started feeling numbness in his arm. We believe that the nerve damage that he sustained was because the nurse may have done a malpractice negligence and poked the needle too deep, and rather than going on an angle, just going straight into the arm. Well, it ended up being that, yes, that may be a malpractice, and sometimes it happens. However, the biggest malpractice was that when the patient went back and complained about this, the neurologist in the institution did not do the proper treatment and kept telling him, why don't we wait a month or two and see if the feeling comes back? Well, our expert found out that that was a malpractice because the nerve was damaged, and you only have about 60 days with the proper physical therapy to make it regrow. And since the 60 days had already passed, this man has to live without any sensation in his left arm forever. Forever.
Holy cow.
So the malpractice was not doing the proper treatment after that, not by cutting the nerve. The nerve could have been cut anyway.
Wow, that's crazy.
That's right. The other cases that I have, for example, a lady went for hysterectomy and ended up having septic all over her body after 2 or 3 days. And she kept calling the doctor, and the doctor just kept, over the phone, giving her antibiotic. Later on, when she went to the hospital, they realized that urinary tract was cut during the hysterectomy. Well, we all thought that cutting a urinary tract during the hysterectomy is a malpractice. Well, guess what? It is not. It's unavoidable consequence that happens a lot of times, and this is medical literature. The malpractice was that when she started developing fever, the doctor did not immediately put her in a hospital, look at it, and put a stent. That's why.
Get it figured out. Yeah. Wow. Oh, I've heard sepsis is bad news.
Oh, it was bad news. She had to be under antibiotic for 4 months, drip antibiotics 24 hours a day for 4 months.
Holy cow. Oh my gosh. Sheesh, you've seen some stuff.
So when you do personal injury, it's not only, oh, I got into a car accident, I have this injury. A lot of different things comes with it that is related. And you better have some knowledge about other portions of law to know whether you can handle that portion for the client also, or are you going to pick up the phone and call 1-800, the lawyer who's expert in that area to get involved.
I think that a lot of people hesitate to question their doctors. I know I'm very trusting of my doctors. I think not everyone is, but a lot of people are. How do you help clients sort of balance that, tendency to trust medical professionals with standing up for themselves if something feels off?
A lot of psychology. You are absolutely correct. There is generally a lot of credibility to the doctors and trust, and for the good reason. Great majority of doctors are good. They pay attention. They care for their patients. But mistakes do happen, and it's not all of the time. It's not about what the doctor did is wrong. It could be the facility that the doctor is, or things that's going wrong. It is important to sit down with the client and let them know that, unlike the insurance companies, it's important to make sure that you bring the claim, if it's worthwhile, to let the healthcare professionals and the facility and the doctor make sure they don't make the same mistake toward other people. It's not all the time about the money. It's about the fact that you want to make sure that no other innocent patient becomes a victim.
Right.
I have a very good example for that. Years ago, I had a family who their mother died of a heart attack. The whole story was that this person had a heart attack on a cruise ship. And the doctor on the cruise ship was able to stabilize her, put her on a helicopter, bring her to the shore. They went to the hospital. And during the proper procedure of giving her one injection to stabilize her, half an hour later, she had a massive heart attack in the hospital and died. Come to find out that the syringe that the hospital had used was a defective syringe that actually pushed the air bubble into her veins, and that's what caused her to die.
Oh.
Well, this case was not about the doctor doing anything wrong. It was about the hospital personnel who had received the email and the message from the manufacturer of the syringe. Destroy these syringes. We found out that there's something wrong with it. Not to pay attention.
Wow. That's a crazy story, James.
You live long enough, you hear everything.
You hear it all.
Yes.
You mentioned before about the accountability side or the prevention of like shedding light on some things. Is that something that you see a lot beyond compensation, that clients want to see some other outcomes that might help going forward?
Yes, mostly in the medical negligence portion. I hear that a lot from the clients, that they want accountability. It's not necessarily all about the money. Absolutely. On the accident cases also, I hear that, but I have to be realistic with them, with my clients, to say, look, so you go to court and you prove that this person ran the red light. Not going to make any difference. There's no money out of his pocket, his insurance company's. And the only thing is going to happen is that his premium may go up. That's it. You still want to do.
Right. So choose your battles, right?
Correct.
You've handled obviously both injury and insurance matters. How do these two areas overlap when a medical error happens during accident recovery?
Well, again, if the person who has caused the accident and the original injury has big enough policy, it makes it easier to just go through that policy and put all the medical in front of them and try to recover. It's faster, it's easier, it's better. But a lot of times you will find out that the person who caused the accident has a limited policy. Let's say only $25,000 policy. And now because of the medical malpractice that was committed on your client, the value of the case may have gone up to $250,000 to $500,000. Well, you can't count on the original person to pay the whole thing because the policy limit is $25,000. In that situation, you want to bring a claim against the doctor and or medical facility and go through. But if the person who caused the accident has the large insurance policy, why would you want to have two cases? Why would you want to have two sets of cases? And medical malpractice cases are extremely expensive because right from the beginning, you have to hire an expert. By the time on a simplest one, you get in front of the jury, you already have spent $35,000 to $40,000.
Wow. Yeah. That's a good thing for people to know too before they go down that road, huh?
Absolutely. Plus, the fee structure in medical malpractice is totally different. The more money you get for the client, the percentage of attorney's fees comes down. So if the case is not big enough, if your case is only a $50,000 case on medical malpractice, by statute, the attorney gets 40% of the $50,000. Plus, the cost is also deducted. So what is it left for them?
Yeah. Yeah. Again, choose your battles, figure out what it's worth. Yeah.
Absolutely.
Yeah. All right. Well, interesting stuff as always. That's it for today's episode of the Ethical Advocate for Accidents with James K. Sadigh. If your recovery hasn't gone as planned and you suspect something went wrong with your care, visit jamesksadigh.com to learn more about what your options are. And if you found this discussion helpful, please be sure to subscribe, leave us a review. We greatly appreciate it. James, always appreciate your time. Thanks so much.
Thank you.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.